I describe this as the most dangerous and irresponsible decision by the Supreme Court. It's the slavery decision by the U.S. Supreme Court in 1857. I think that's a statement with which many constitutional lawyers in the United States would agree.
What Donald Trump has hailed as a big win, the US Supreme Court has ruled that former presidents have criminal immunity for some of their actions whilst in the White House. The decision from the conservative leaning court did not dismiss outright Trump's charge of plotting to overturn the 2020 election, but it does strip away some of the main elements of the case against him. The nation's top court ruled that for the first time in US history, presidents enjoy absolute immunity for core actions, but it said the final decision on unofficial acts should be left to lower courts. So what does it all mean ahead of that presidential election on November the 5th? Philip Lacovara is a former Deputy Solicitor General for the US. He was also counsel to the Watergate Special Prosecutor during the impeachment hearings of President Nixon. Good evening to you, Philip.
Evening, Carol. It's always nice to be with you.
Great to have you with us. It's a slightly complicated ruling, isn't it? Just talk our listeners through what it means for Donald Trump.
Well, it actually is very simple for Donald Trump. It essentially means that he's getting away with all of the actions relating to the uprising on January 6th. The Supreme Court's decision seems to be complicated, but the net result of it is that they've essentially not only put off any trial of former President Trump until after the November 2024 election, but made it virtually impossible for the prosecution to go forward with any of the charges against him relating to those events.
But they did seem to say that because this was related to unofficial actions, that it could be passed back to a lower court.
Well, they said that there might be some pieces of the indictment that might be unofficial, but the way they defined the two elements for which a former president would be entitled to immunity from criminal prosecution for otherwise violating federal criminal law were drafted so broadly that I think there's very little left that the prosecution could go forward with. And I think that's what Jack Smith, the special counsel, the chief prosecutor, is probably ruling this evening.
So Donald Trump says it's a big win. In a way, he's right, isn't he?
Oh, it's an enormous win for him. I will say, and this is my own opinion, I'm happy to say I think it's shared by most constitutional scholars. The decision today is essentially made up of whole cloth. That is, it has no basis in the text of the Constitution, no basis in the principles that were created in the Constitution of the United States. And it is simply the creation of the dream of the right-wing Republican establishment since the case that I argued 50 years ago, United States versus Nixon, has sought to insert into the Constitution what is described as the imperial presidency or the unitary executive, and that's what the six justices in the majority have explicitly done by formulating this unheard of immunity, which I would say, until this court, no justice of either party would have taken seriously. I don't think anybody could disagree with that statement.
We should say, of course, that this is just one of many other legal cases that Donald Trump is facing. We've already seen him convicted on one. Are there more serious cases looming between now and November the 5th?
Unlikely that any will come to trial. And so I think the American voters will have to go to the election boxes or the voting booths just with the conviction in the New York fraud case, the one relating to the hush money relating to the porn star affair. The case in Florida that's in the federal court theoretically remains open. That's the case in which Trump is accused of hoarding top secret documents that he was supposed to have returned to the government, but had scattered around his mansion in Mar-a-Lago. That case is on such a slow track, thanks to the judge that Trump appointed after he lost the election, but before the reins of power were turned over. And then there's the Georgia state case, which largely parallels the one that was before the Supreme Court. And it's likely that Trump's charges, the charges against Trump in that case, will have to be dismissed for the same reason that they're likely to fail under the Supreme Court's current ruling.
And does today's ruling by the Supreme Court mean that if indeed Donald Trump does win another term in the White House, and that certainly seems quite possible, particularly after the latest debate with Joe Biden, that he could use this ruling to perhaps overturn even the conviction that he's got at the moment?
I don't think that will affect the New York state conviction. The decision today deals with what we call the separation of powers, which relates to the conduct of the three branches of the national government, and it affects conduct that is engaged in by a president in his official capacity. But the New York case involves purely private conduct by Trump in his businesses, that is the books and records of the Trump enterprises and the fraudulent concealment of hush money payments, claiming that those were legitimate business expenses. So I think this decision does not affect the conviction in that case on which Trump is to be sentenced in 11 days.
So, what happens if he is indeed sentenced to a prison term?
Well, he probably would not have to begin serving any prison term before the election because prison sentences are normally held in abeyance while appeals run their course. That could easily take a year or more. If, as seems likely, he is reelected president in November, it's highly unlikely that either as a matter of law or practicality, he would actually be serving a prison sentence while he's the president. I think that's just unimaginable. So as a practical matter, Trump has gotten a couple of get out of jail cards free.
And Donald Trump has long railed against all the legal cases against him, saying that they're all political charges. They've all been brought by his opponents who are trying to use lawfare to prevent him becoming prevent him becoming president, to damage his campaign. But in a sense, this ruling in the Supreme Court is partly a result of politics, isn't he? Because many of those people on the Supreme Court are people who were put there by Donald Trump when he was last in power.
Yes, and they were, I think the key point, Carol, is that they were screened for a promotion to the Supreme Court because of their ideologies. These ideologies were well-fashioned and well-known while they were serving on lower courts. And so it was predictable that they would embellish this unitary executive or imperial presidency concept that has been developed by political theorists in the last 40 years or so. And so Trump has benefited politically from the political screening of the justices that he and some other Republican presidents appointed.
We've always heard, well, no one is above the law in the United States, but I wonder whether this ruling actually says that, well, in some instances, presidents are above the law.
Unfortunately, that's exactly what it says. It says that the normal criminal laws that apply to every other person in the United States, including other government officials, do not apply to the president of the United States. That is such an extraordinary concept that, as I said earlier in our conversation, no one would have taken it seriously 20 years ago, much less at the time the Constitution was framed in the late part of the 18th century.
So that has repercussions well beyond a potential Trump presidency.
Yes, during the debates before the Supreme Court, one of the justices in the majority said, that they would be writing for the ages. And indeed, that is true to the extent that this decision survives indefinitely in the United States. It licenses any scoundrel, thug, authoritarian dictator who manages to win a majority of electoral votes has essentially license to engage in any sort of criminal mischief that seems expedient to him. And I think in an opinion piece that's going to be posted in a few minutes, I describe this as the most dangerous and irresponsible decision by the Supreme Court. It's the slavery decision by the U.S. Supreme Court in 1857. I think that's a statement with which many constitutional lawyers in the United States would agree.
Philip Lacovara, former Deputy Solicitor General for the United States. Really good to speak to you. Thank you so much for joining us tonight.
Very well.